Good morning, everybody. Thank you very much for coming. I see some people continuing to come. That's the advantage of being able to look out of the door. So I think because this is the last morning of the conference, people might be checking out of their hotels or whatever. So let's wait just a couple of minutes before starting, just to say that I'm Charles Rabb. I'm a joint organizer of this panel with Ivan Zeke, who is unfortunately not able to be here. So when we start, I think the first person to speak will be Ivan, giving an additional welcome and also outlining something about today's panel. And then I will take over, and then we will have a succession of speakers who will be introduced, I think, by Ivan very shortly. So let's just wait until the last few people are coming in, and then we can start. And we hopefully will have time at the end for question and answers. And the guy with the bell traditionally comes to ring it 5 minutes before we finish. He will come at, or she will come at 5 minutes to 10, and we will aim to finish it promptly at 10 o'clock. So I think perhaps we should start now. And
Okay.
I would like to turn over to Ivan. This is an experiment because this is the first time that CPDP has had a panel which was moderated from outside the convention premises. So we'll see it works. The technical people, and thank Carlos in particular, who I was talking with earlier, have set up this arrangement, and we think it's going to work. Ivan.
So, welcome everyone from my part too. We are starting our panel discussion about DPAs and certification systems. How good are they as compliance instruments? We use the acronym DPA for Data Protection Authorities and not for Data Protection Acts, for example. I'm Ivan Székely, an old CPDPer. Unfortunately, as Charles already told you, this time I cannot be with you in person. I will be moderating the discussion online. This is quite a challenge, and I count on your cooperation. I would like to introduce the participants. Charles Rabb is Professor Emeritus of the University of Edinburgh and co-director of the Centre for Research into Information Surveillance and Privacy, CRISP. He has been a fellow of the Alan Turing Institute and co-chair of the Institute's Data Ethics Group. And he is a member of the UK Home Office Biometrics and Forensic Ethics Group and the Police Scotland Independent Ethics Advisory Panel. His research areas are focused on privacy, data protection, surveillance, regulatory policy and practice, identification, data ethics, security, and democracy. His many publications include The Governance of Privacy. I found it on, maybe you can see it, The Governance of Privacy with Colin Bennett. And the report Surveillance, Citizens and the State. Marit Hansen is the only DPA on the panel. She is Privacy Commissioner in Schleswig-Holstein, Germany, and head of the Unabhängiges Landeszentrum für Datenschutz, ULD, since 2015. Now it is 2025, so it is a jubilee year for Marit in her position. Congratulations, Marit. Before, she was Deputy Commissioner and in charge of the Privacy Technology Projects Division and the Innovation Center Privacy and Security within ULD. Since her diploma in computer science, she has been working on privacy and security aspects with a focus on privacy by design from both the technical and the legal perspective. Colin Bennett is Emeritus Professor of Political Science and Fellow at the Center for Global Studies at the University of Victoria, British Columbia, Canada. For over 30 years, his research has focused on the comparative analysis of privacy protection policy at domestic and international levels. In addition to numerous scholarly and newspaper articles, he has published 7 books on this subject, including The Governance of Privacy with Charles Rabb, again, as well as several policy reports for national and international agencies. His current work focuses on the importance of privacy for democratic rights and on the capture and use of voters' personal data by political parties in Western democracies. Sebastian Ziegler serves as chair of the Privacy Symposium and president of the Euro-Privacy International Board of the European Center for Certification and Privacy. He also serves as president of the IoT Forum. As founder and director general of Mandat International, he is actively supporting international cooperation. He initiated and took part in over 30 international research projects, largely related to data governance. He is also a qualified expert in data protection, accredited for Europrivacy, Europrise, and ISO certifications. And finally, I'm Ivan Székely, social informatist, an expert in the multidisciplinary fields of data protection and freedom of information. As former chief counselor of the Hungarian Data Protection Ombudsman and associate professor at the Budapest University of Technology and Economics, I am at present senior research fellow and counselor of the Vero and Donald Brinken Open Society Archives at Central European University, Brinken OSA Archivum in short. My research interests and publications are focused on information autonomy, openness and secrecy, privacy, identity, surveillance and resilience, memory and forgetting, and archivistics. Now a few words about how the discussion will be conducted. Each panelist will have 8 minutes maximum to expose their views on the topic in the first round. I ask all speakers to keep to the time. Between the presentations, Charles, I, or a fellow panelist may ask short, clarifying, or provocative questions. After the individual presentations, I will invite the audience to ask questions or make comments. Finally, Charles will summarize the discussion. Now I turn to Professor Rabb and ask him to read his introductory notes. Technical staff, the next slide, please. Thank you. Charles, the floor is yours.
Thank you very much, Ivan. Now you know who we all are, and now you will hear what we have to say about today's topic, which is DPAs and certification systems. How good are they as compliance instruments? I think that I want to give a general overview of what the panel is concerned with and about certification before you hear in particular detail from the experts who deal with it later on this morning. We've brought together a panel of academic and practitioner experts who will be introduce their talks in a few minutes. And we're especially grateful, I think, to Colin for having suggested this year's topic on certification. Now, Colin and I, as has been mentioned, published a book about 20 years ago called The Governance of Privacy. It's not yet on Netflix, but we hope for the worst. And in that book, we looked at a variety of instruments for protecting personal data. And a number of these instruments were, and perhaps still are, significant to safeguard and enforce the right to information privacy and to regulate relationships between data processors or data controllers on the one hand and data subjects. And amongst these instruments that we talked about in the book are privacy certification systems, and they were really in their infancy when we did the book. There were privacy seal programs, privacy marks, and things like that. And in those days, among the main examples, and they still exist, are things like the trustee organization, which had several programs that included a children's SEAL program, an e-health SEAL program, and a safe harbor SEAL program. Do you remember Safe Harbor? There were also a Japanese SEAL system called GDPR, and the Canadian Standards Association's privacy mark scheme, which is Web Trust. The Better Business Bureau had BBB Online. Now, these still exist, and you can still read about them if you do a search for them. But in those years, they were still in relative infancy. They were a very undeveloped state, I think, in terms of their legislative status, their legal status, the institutional arrangements to ensure compliance, and also public awareness. I think today's panel is going to cast some light on how far systems like that, in the next generation of successors, have come to play an important part in helping to establish a better means of regulation, or indeed co-regulation, if you like. Now, Colin and I wrote about privacy seals in relation to standards and certification as self-regulatory mechanisms. But in the EU, and especially in the GDPR, there's now a statutory basis, as you know, for certification and for oversight arrangements that include an important role for DPAs, and that's where this panel comes into its own, because we want to focus upon the importance of DPAs in the whole picture. And there are also other legal arrangements of a similar kind being developed elsewhere in the world. I think there's still room for skepticism and debate about the ability of certification schemes and standardization to do what they claim to do, or to do what people hope they would do, even if they're built into institutional and legal foundations such as laws and supervisory authorities. Well, what does the GDPR offer to assist in the success of certification? The Articles 42 and 43 may be somewhat familiar to most of you of the GDPR, and they set out provisions for the formation and the use of accredited certification systems so that data controllers and data processors can demonstrate their compliance with the law. And briefly, very briefly, and very generally, Article 42 requires member states and the European Commission and the European Data Protection Board and DPAs to encourage certification and seal programs, taking account of specific needs of small and medium enterprises and micro enterprises. And the schemes, of course, are voluntary, but without prejudice to the tasks and powers of the DPAs. And so if controllers or processors who aren't regulated by the GDPR adopt certification schemes, these must operate alongside whatever binding and enforceable commitments that otherwise exist under contractual or other legally binding instruments to apply appropriate safeguards and to include regard for the rights of data subjects. Certification bodies or DPAs can grant certificates for 3 years, renewable, according to criteria approved by the EDPB or by the relevant DPA in one of the member states. And DPAs may withdraw a certificate where the conditions fail to be met. And Article 42 goes on to say, and this is a quotation, where the criteria are approved by the board, this may result in a common certification, the European Data Protection Seal, and we will hear more about that in due course. The board, the EDPB, has to compile a public register of all certification programs, seals, logos, marks, and so on. So compared to 20 years ago, it's a much more formal set of processes, much more accountable, if you like, and publicly inspectable set of arrangements. Now, Article 43, that deals with certification authorities, their powers, their obligations, and the role of a DPA or other competent national supervisory body to oversee and exercise accrediting powers and other powers in relationship to these certification authorities. Now, to become accredited for a 5-year period, A certification body must, for example, satisfy the DPA of its independence and expertise, and that it will respect the established criteria, that it will set up criteria for accrediting or withdrawing the accreditation of controllers or processors who apply for the seal or the mark, and that it will set up complaints procedures. So we begin to get an architecture of accreditation and approval and the role of the DPA in all of this. Now, to illustrate this, let me go outside the EU for a moment and refer to the UK's arrangements. And of course, the UK data protection legal regime closely follows the GDPR after Brexit, which we unfortunately in the UK legislated for. And in that, the ICO, the Information Commissioner's Office in the UK, plays a central role in certification. It's provided guidance on certification to inform data processors and controllers and to help them apply for certification. To obtain certification, you need to apply to the certification body that delivers that scheme. And this includes guidance on how an organization can become a certification body so that it can issue certificates to the data controllers or the processors that want to apply to become members of seal programs and the like. And the ICO itself maintains a public register of certification schemes. That's under Article 42(5) of the UK GDPR. Now, I think that looks a little bit complicated. It looks like a multi-level infrastructure and network of bodies, standards, requirements, roles, and relationships across a whole infrastructure. And I don't want to go into the detail on this because time is short, but the ICO has a way of describing this whole architectural framework involving many different kinds of activities from the ICO itself and the UK's accreditation body, which I'll mention in a minute, and what the ICO does to approve and publish certification criteria, and so on. Let's look at it from the standpoint of a company, a processor, or a controller. Suppose they want to come under one of the available certification schemes and to use the logo, the seal, and it applies to one of these organizations that offer such a program. How do the bodies that want to offer such schemes become accredited in the first place, accredited to do so? Becoming a certification body in the UK involves a further organization beyond the ICO, and that's called the UK Accreditation Service, UCAS, which is the UK's national accreditation body. And UCAS operates the accreditation procedures and requirements, which include ISO standard, and it charges a fee for organizations that want to become established as accreditation bodies. We're not talking about companies now, we're talking about the accreditation bodies. Within the UK GDPR's requirements, these accredited certification bodies will certify data controls and processes in a wide variety of fields or sectors, for example, medical or health field, against the ICO's approved criteria for the certification of controls and processes. And those criteria are, of course, based on the GDPR, its principles, its rules, obligations, rights, and they also involve related ISO standards. Well, what else does UCAS, the accreditation body, do in the UK? It provides the ICO with details of applications that it receives from companies, from organizations that want to act as accrediting certification bodies, as well as providing details of the accreditation that UCAS itself issues, refuses, or withdraws. The UCAS is also in touch with the ICO to provide the ICO with a summary of the complaints and appeals that they receive from companies or other organizations. And UCAS is also required to notify the ICO of any nonconformity of the certification body, and this is for enforcement purposes by the the data protection regulator, which could lead to suspension or withdrawal of the accreditation or result in an infringement of the UK GDPR. The certification bodies themselves are required to inform the ICO about all applications that they receive at the application stage and the reasons for granting or withdrawing a certificate to a company saying, you're okay, you're accredited, you can use the seal. So in short, for a company to be able to tell customers or clients that it's part of a seal program is a rather intricate process at several levels, involving shared competencies and requirements across different kinds of organizations, criteria against which to evaluate performance, compliance, oversight arrangements, and quite a lot of guidance that's apparently needed for these journeys. And it bears out what Colin and I wrote about in our book about DPAs, that they're not only in business to enforce the law and to issue fines, but to establish criteria and to guide, to educate, to advise, and indeed to learn itself as a regulator from those who have to comply with the legal requirements or who want to offer schemes like we've been talking about as certification. So how well can DPAs perform these tasks in relation to certification? How well are they actually coping with that? This comes back to what the panel is going to be talking about. Are the relationships between DPAs and other players as complicated as I've suggested the formal procedures look like? And are the safeguards that certification arrangements aim to guarantee, are they really working to the benefit of consumers and the general public? So today's panel aims to find answers by looking at the current state of play in a couple of instances on certification schemes based upon the panelists' own roles and experience and perceptions of what's going on. Marit and Sebastian will focus upon the European experience, and Colin will tell us about the Canadian scene, which I think is very important. You in the audience may have other insights and other contributions to make, and so we welcome your questions and your statements after the panelists have spoken. If you look at the specifications of this panel, we asked 4 questions. How have certification schemes developed in the EU? What problems and opportunities have been encountered on the way to certification? And what are the experiences of DPAs and certification bodies within these schemes as part of a whole regulatory toolkit? And what are the views, very importantly, of consumer and civil society organizations about such voluntary schemes? To what extent can these schemes contribute to building trust, confidence, transparency, and accountability? So that's all I think I have to say for now, and I'd like to turn over to Marit to tell us about Europrize and other things. Thank you, Marit.
Technical staff, please, next slide. For a few seconds, you can read Marit's short CV, just for a few seconds, and then I will ask you to switch to her presentation, and she will be able to navigate with a clicker within her own PPT.
Yes, thank you very, very much, Ivan.
Please switch to Marit Hansen's presentation. And Marit, the floor is yours as soon as you see your presentation on the screen.
And I do. Thank you very much, Ivan. Thank you all for inviting me here. Unfortunately, I can support the estimation from Charles about it's complex. And we are not there. But still, where are we? I can give you some oversight. So DPAs and certification systems, what is the reason for that? The controllers want guarantees. There's a desire. They don't want, they want to distinguish whether we are here on the left side of a broken bridge. They are processing which has vulnerabilities and does not work, and they are not aware of what is really happening or their legal basis. They want guarantees for being on the right side here and having the sufficient safeguards in place. But right now, very often, they cannot distinguish which is the case for their data processing. So they have no idea. This is one motivation for certification, that something should show they're on the right track. And I want to inform you about what is there in the GDPR, why is it supported? And not what Charles said, but in addition, from the perspective of those who want certifications, then the status, which is not satisfying yet, and the main question whether GDPR certification can work. This is an open question. I can already answer that. So the desire for guarantees, how is it reflected now in the GDPR? The EDPB, the European Data Protection Board, in one press release last year said GDPR certification contributes to the demonstration of compliance efforts. So contributes, it's not the same, it contributes, and to increase transparency and trust, okay? It allows for better assessment of the degree of protection, better assessment, not the best one, not the only one, offered by products, services, processes, or systems used by organizations that process personal data. Okay. Several people may now assume, okay, I can buy something going into a shop, grabbing from the shelf, now with the cardboard box, this has now a mark, a seal, looks nice, and now it works well, and there's a guarantee. It's not working like that. It's not about products, it's about processing operations by the controller or processor. So not a manufacturer, they're not addressed by the GDPR. Manufacturers are outside. If a manufacturer also is in the role of a controller or processor, so processing personal data by themselves, then they are also affected, but not those who produce, not the code producers, for example. It's not a product certification. We see right now that much is happening on the European legislative side, the AI Act, the Cyber Resilience Act. They have the product-oriented approach, also some system orientation and process orientation, but it's about the CE marking. Probably you see if you look around, many CE markings where you also should rely on this is working. And this is not what the GDPR is about. So what is there inside? The certification or the mechanism, the approved certification mechanism, it can be used as an element to demonstrate compliance. So if a controller gets a certification, and it's voluntary, they can use this certification as an element for guaranteeing or for demonstrating compliance. No real guarantees. I think it's mostly interesting for processors. So not so much for the controllers themselves, it could, but usually the processors want to sell what they are doing. So the data center, for example, if the controller wants to decide which processor should help in data processing, then if one of those has a certification mark saying my processing operations are certified according to this mechanism, then it is, well, an element, only one element. There can be more elements, of course. There are many requirements inside, but this is the only, I think, binary element. It has a certification or not. And in fact, we demand it's not so binary. It's if everybody then later on has, as a data processor, certification, you should, of course, look into what is really the certification about. Reading about it, a short paper, a long demonstration. And this is also in line with what is now happening with the product orientation of Cyber Resilience Act or AI Act, that there will be also something where there's a guaranteed quality assurance. So you see here an element to demonstrate compliance with data protection by design by default and security processing and how to select a processor. And it's also important because of we heard already about Brexit, we heard about safe harbor. What about transferring personal data to third countries with not the same level? So this is also something where it's inside Article 46, but it's very special now. So what is about the status? Computer security is very much related with data protection, of course. We see so many security certification. This is from Wikipedia, 11 pages, nobody can read anything, only to demonstrate it's very, very much. So is it the same level now on data protection certification, in the beginning, so 2016, when we read the first time the GDPR, we thought, yes, there would be hundreds perhaps in Germany alone. We see the status is this. You may read a little bit because it's about 9 altogether in 2025. It's 3 on the European level, we will hear about that, but not only restricted to one member state, but 6 others. It's not much. And if you read the third column, it's from Luxembourg, Germany, the Netherlands, Austria, Belgium a little bit. So it's a very centered approach. There seem to be some ideas, we want a certification. I know about a more wider candidate list, but it's not hundreds, it's not 100, it's less. And perhaps it will continue go on with some other business models, we'll see. This means we haven't seen in my work a single certification yet. So what about my experience on that? We haven't seen anything. There are a few now, it's beginning. Why? Because it was very complex to discuss everything. It's not so easy to read Article 42 and 43. It's not totally clear, and especially not if it's about if there's a certification in one member state, how valid is it in the other areas? What about a withdrawal of certification? Be prepared. So there's no there are few certifications. There has been no withdrawal of a certification yet, because if we see that this might happen, I'm pretty sure that we will see many complaints, perhaps of competitors, perhaps from people very engaged, saying this now should not be a certification. This means the process will restart there with the question of withdrawal. And it will be a rare thing. It has to be, we have to have legal certainty. And if you really want to withdraw a certification as a data protection authority, you will have to do a very thorough investigation on that. So I'm not sure whether it will ever happen. Certification obstacles. So we see the famous saying from Bruce Schneier, and everybody knows that security is a process, not a product, but the same is, of course, valid for data protection. And therefore, we have the main limitation: is certification only a snapshot? Is it something where we may have the full GDPR fulfilled, all the obligations? By the way, codes of conduct, which are a little bit related, so have a parallel mechanism for self-regulation in the GDPR, there you can pick and choose. This code of conduct can concentrate on a few things in the GDPR. The certification is for everything. It's really, it's ambitious to do this stuff, and it's ambitious to receive then the certification. But can you really be sure? So there should be now, again, the process orientation, and we will see and can discuss this later on. I will stop here. Thank you very much. And further reading, you get the slides.
Thank you very much, Marit. I've been formulating a few questions in my own mind, and perhaps the audience is as well, but let's hold those for a while and turn over. Perhaps, Ivan, do you want to formally turn over to Colin, or shall I do it?
Little time,
Okay.
I ask the technical people to switch back to the panel presentation again. And a quick question now to Mary. In your practice as a privacy commissioner, have you ever had a case where a data subject submitted a complaint to your office regarding certification? I mean, if there was a privacy seal on a website, but the service provider acted in a contrary way. Have you had such a case?
We have been informed about fake GDPR seals, fake ones, not real ones, yeah. And then we could do something. We had done, and then they had to remove it, but it's a little bit outside our usual work. So no real certification and no complaint about a real certification.
Thank you. So next slide, please.
I don't have any slides, Ivan.
Yes. So the floor is yours. Colin Bennett.
I don't have any slides because I've only just decided what I want to say. Thank you, everybody.
Please keep the original slide about Colin Bennett.
Okay, if necessary. Yes, there I am.
Yes.
I thank you, Ivan. Thank you, Charles. I suggested this idea because I think it's crucial. The idea of certification has been around a long time, as Charles mentioned. I believe it's an extremely good idea. It arose at a time in the late 1980s and 1990s, sort of a historical perspective here, when the data protection community were looking around for innovative ways to supplement the law. And as Charles mentioned, that's when other ideas, often imported to Europe from other countries, including Canada, like codes of practice, privacy impact assessments, standards, certifiable standards, and certifications, entered the toolbox of policy instruments, and those all found expression in the GDPR. Now, first point to make is that these words are not always used with precision. It irritates me sometimes when I hear people talk about standards and codes as if they are interchangeable. They're not. And I think that that's one first thing to be wary of. But anyway, there's been a debate over 25 years about how these processes might improve data protection. And I think we've made progress. But as Marit has said, I think that a lot more needs to be done. Ivan said that I wanted to say something about Canada. There has not been enough Canadian content at this conference. I just wanted to put that out there. So I am the Canadian content. I'm flying the flag, right? You may have heard that our country's under a certain amount of threat at the moment. So
You're invited to come to the European Union.
well, that's another. Well, we're pivoting to Europe, according to Mr. Carney. So this is part of my persona. Anyway, so the ideas have not really taken off. There's a lot of false starts. I think one of the things to first of all say is that pure market incentives for certification is not sufficient. If you tell a company that, well, you've got to certify, they'll say, well, why? And their lawyers will say, why? Right? We've got to comply with the law. Why should we spend all this extra money in order to go this extra mile? So you need other things. And what are those other things? Well, they're regulatory. If there's regulatory pressure, number one, I want to say more about that. If there's reputational issues, right? Number two, if a company has been in the media because of a data breach, etc., they may very well see that it's a good idea to certify to data protection standards in order to increase their reputation. And thirdly, there are contractual reasons, right? And I think this applies particularly to processors, where a controller might say, well, we want to be assured that the data that we are responsible for is processed responsibly, and certification then plays a role in a contractual situations. So I think they have a real potential to be a good compliance instruments, but it hasn't happened yet. Sebastian's going to talk about Europrivacy, and we have Europris. And I think that these systems actually on paper look really, really good. The ingredients are in place. Certification bodies have been approved in various national jurisdictions, not all. Auditors are accredited. We know what it looks like to have a good certification. So the system, I think, has far more credibility than it has in the past. I think DPAs can be assured that there's a certain amount of independence. Maybe it's early days, but the take-up has been slow, as Marit has said. And I think the same with Europris. There's also issues about interoperability of these systems. I think Sebastian's going to talk about that. But there is this tricky relationship between certification and investigation sanction. And it's a really tricky one. Most DPAs will say that this is not a, quote, get out of jail free card. It's an element, but not a guarantee. It's something that will help you if you get in trouble, but it's not a guarantee. Is there more that can be said, however, than simply saying, it's a good idea, right? It's a good idea to increase your reputation. Is there anything more that can be said? And this is where I want to say something about Canadian privacy law reform. Our law on private sector dates back to the year 2000 still. It's incredibly dated. And we've been talking about reforming it for 10 years or more, and it hasn't happened. Our law is actually based on a standard. In the body of the law is a certifiable standard that was approved by a Canadian Standards Association back in the day, with all the elements of the fair information principles. And the idea back then, I go back a long time, as not that long, but, I have a history, I have a memory. And the idea was that companies might be able to take that standard out of the law and certify to it with one of our standards certification bodies. Hasn't happened. Never happened. And it never happened because the DPAs were very suspicious of this. And it's been in place for 30 years. So in our law reform efforts that have been going on, we now have bills in place which hopefully will go through in the next couple of years. And there's all kinds of elements there, some of which have been borrowed from the GDPR, but not increasingly. But certification plays a key role in the law. And it says, and I'm going to read something, that where a complaint, to Marit's point, raises an issue in respect of a certification program, somebody complains about a company that has been certified, then the commissioner, should investigate that complaint. But, and this is the key, the commissioner must not recommend that a penalty be imposed on an organization if the commissioner is the opinion that at the time of the contravention, the organization was in compliance with the requirements of the certification program. So this goes a step further. The commissioner under this scheme can recommend fines, but if the company has been certified to a certification program that the commissioner has in fact improved, including alternative dispute resolution, then he cannot recommend a fine. Now, so that strikes me as interesting, an interesting sort of carrot for organizations to sort of think about if they want to go through this. The second point I just want to make is this: can they go further? Can, in their investigation and compliance functions, say, for example, there's a massive data breach, can they say to that company, go away and get certified? We're not going to fine you, but we are going to order that you get certified, either to one of the programs that Europrivacy approves, or ISO 27000 or something like that. Now, we do have evidence of that. That has happened in some jurisdictions. It has happened in Canada. It has happened in a few, and I'd like to see it happen more, quite frankly. And I don't see quite what, and GPAs are reluctant, and certainly companies are reluctant, but I don't see why it shouldn't happen more, because you're not, finding it has a role in this process, obviously, under the GDPR, but it doesn't necessarily fix the problem. But if you say to a company, go away and pay to get a certification, then you are in fact. Now, there are issues there. There are legal issues there. There are compliance issues there. I recognize that. But I think that could happen further. A couple of final points. This is a burden on overworked and under-resourced DPAs. There's no question about that. Our law says that the Privacy Commissioner has to look into these systems and be assured that they're independent. That's a lot of work, and it's a lot of resources. And I talked to our Privacy Commissioner about that, how do you have the resources? And he said, well, not really, we're gonna have to ask the government for them, So I'm not sure how that's gonna go through. The final point I want to make, if I have a bit of time here, is what do we actually mean by compliance? Okay? Sebastian may want to address this, but it's all very well to say, well, you comply with the rules, comply with the law. And on many aspects of the GDPR, that might be quite clear what compliance means. But on some aspects, it might not be. Okay? We all know that there are nuances, there are complexities. Is that a legitimate interest? Is express consent required? And companies obviously have an incentive here to have more flexible, interpretations of the law. So there is a danger in certification that certifications can be locked in to legal interpretations that might not stand scrutiny if there's an investigation. Now, I don't know of any examples in Europe, and certainly not under Europrivacy, it's in the early days, I suppose, but I do know of examples in Canada. I do know of examples in Canada where companies are doing somewhat questionable things, which have not yet been sort of investigated by the commissioners, and they want to lock in a certification and say, okay, well, we've been certified to these practices, and there you go, right? So that is a danger in this area. I'm interested to hear what Sebastian had to say about that. Yeah, okay, so I'm going to wrap up now. Well, Ivan did ask us to say something about the role of the privacy advocacy community and the civil society organizations, and I've written about that in my work later, but I'll perhaps throw that view in when we have a Q&A. Okay, thanks.
Thank you. Thank you, Colin. In particular, for extending the scope of our discussion to extra EU issues. The next slide, please, technical staff. Our next speaker is Sebastian Ziegler. For a few seconds, you can reread his short CV, and then please switch to his presentation, to his PDF file. It was a PDF. Could you please switch to this? And Sebastian, if you see your slides on screen, you can use the remote clicker and you can navigate through this.
Thank you very
So
much.
that's
I don't
great.
see the
Continue,
slides
Steve.
yet. No, it is. Thank you very much. First of all, thank you very much for organizing this panel. I think it's very timely, very important. So Europrivacy, we'll speak a little bit about Europrivacy, the experience we had so far, the ongoing developments and some of the challenges we face and I think we can address. As we all know, the GDPR was adopted now about 9 years ago. It entered into force in 2 days. We will celebrate the 7th anniversary of the entry into force. And as it was mentioned before, Article 42 does not only give the mandate, the competence to EDPB to adopt certification, but states shall encourage. So member states, Commission, EDPB shall encourage. It's a clear mandate, not only to say it's possible, we have to do that. And one of the reasons why so Europrivacy has been approved by EDPB, the criteria have been approved by EDPB, and accreditation, the fit for accreditation has been approved by European accreditation, which also took some time. So that's another element for GDPR certification. You have these two aspects, the criteria and the accreditation procedure, which are two elements which are concurring. Now, why is certification, why does the GDPR state that it shall encourage? And when you read the GDPR, you realize that certification is not just an instrument among other instruments. Of course, when you just read Article 46, you think, okay, you have 4 instruments available to the SMEs, plus 1 for member states. But you would say, okay, finally, what is the difference? But when you read the GDPR, you realize that there are 73 references to certification in the GDPR. It's more than all the references to the 3 other mechanisms. So let's dive a little bit into it. And Merit mentioned before, it's the only instrument mechanism which is referred to by Article 25 to demonstrate data protection by design by default, the only one. If you look at the adequacy of data controller, you have 4 instruments, but you have only codes of conduct and certification which are recognized as adequate, as relevant elements to demonstrate the adequacy of the data controller compliance. Same for Article 28, Code of Conduct certification. Article 32, security. Again, we see there are differences in the GDPR in terms of recognition of the legal effect of these different instruments. And this is something very important. Also for the impact on administrative fines. Again, it's not casual or a surprise if SCC and BC are not mentioned under Article 83, while Code of Conduct and certification are specifically mentioned. Why that? Because there's a fundamental difference between instruments where you have a commitment, where I sign a commitment, a SCC, to say, I commit to respect, I commit to protect the fundamental rights of the data subjects, and an instrument where you have control of the effectivity of the compliance, where you have a third party coming to check, is it really the case? Are you really walking the talk? And that, in terms, as Merit mentioned, there's an issue of trust, of confidence. And this is a very important information awareness to raise about it, that not all instruments have the same value, which means that whether it is for the data subjects as a mechanism to protect fundamental rights, or whether it is for B2B relationship between controllers and processors, certification is quite distinct from an SCC, for instance. And that's something that probably, when we're discussing what can be done, where EDPB, the authorities, could also contribute to raise awareness on these differences. Again, without favoring, but being just objective and factual about the legal effect. The scalability, another element which I think is quite interesting with the certification, what we see that when a company invests in a certification, usually most of the work has been done before starting the certification, because companies must comply with the regulation anyway. But what happens when you do a certification compared to SCC? When you deliver a certification, it becomes an intangible asset for the company, which means that instead of focusing on compliance as a cost for the company, which is the case for most companies where DPOs are struggling to get budget because the board will say, okay, we need to give you something, but not too much because it's a cost. We need to invest in what generates revenues for the companies. Their certification, being an asset, an intangible asset, becomes a source of value creation for the company. So it's also a way to transform the relationship and to recognize the work of the DPO and the compliance. And that's another important paradigm shift that can support the proactive adoption of data protection. Value proposition, I will not dive into it. You will have the slides after, but I would say something which is very important. It's not only about risk mitigation, it's also about value creation, about demonstrating building trust, as Merit mentioned. It's about delivering confidence. It's not a commitment on the paper, that there is effective commitment. It also has an impact on the cost of a company. If you are a data controller, you are sharing data with your data processors. You have the obligation to assess, to do due diligence. If you don't do it, you are not respecting your obligations under GDPR. You are supposed to check what's happening with your data processor. And again, certification under Article 28 is recognized as relevant means to demonstrate the adequacy of the data processor. So it's a way to reduce the burden on both sides. So there is also an economic benefit, not only theoretical one, but you can reduce partially the cost of due diligence, you can simplify, you can build trust, so many interesting elements. Let me skip the other elements. Certification, in order to ensure that a European seal can be adopted, you need not only to have good criteria, you need to have accreditation. That's sometimes an issue. We've seen some countries for the European seal, the accreditation authorities are very proactive. In other countries, including large countries, they are sometimes very passive, or sometimes even negative, I would say. So there is an issue to ensure that Article 43 is clearly supported and encouraged in line with Article 42 mandate of member states to facilitate the adoption. We had to work on different resources to support online academy, community website where you have all the resources. And the good news that we have already over 1,000 experts in Europe who have gone through the academy, on over 250 experts all over Europe who have completed the accreditation assessment course. Interprivacy, very quickly, we worked through the European research program on a model which would be international, so translating the European seal into international model. Why? Because if GDPR is about fundamental rights, European citizens represent less than 6% of the world population. And I think it's a great opportunity for Europe to have a model which is not only focused on European citizens, but which can be used by other jurisdictions. So for instance, if Canadians wanted to use the European scheme, they cannot, because it's under GDPR regulation. They cannot deliver accreditation under Article 43. The idea was to work on an equivalent model for with the same requirements. Let me just come back with that. That can be used by any country, and that addresses not only the GDPR, but Malabo Convention and the Convention Rate on 8+. So that's an evolution, and this has been endorsed by the International Accreditation Forum, which means that now we have 95 national accreditation authorities which can use interprivacy. But again, it's not a GDPR certification, but it aims at the same level of protection, the same level of requirements to ensure that the rest of the world can follow Europe and can embrace and adopt the model developed in Europe. We have been working on national criteria extensions, also to address specific obligations in UK, Switzerland, Brazil, India, Japan. We are working currently Singapore, South Korea, California Data Protection Act, I think is ready. I will go very fast. Also working on the same approach to enable SMEs to assess compliance with different regulations. So again, it's not under the GDPR, but it follows the same methodology. So we've been working on e-privacy directive, global DGA, Data Act, and so on, to enable companies to assess by themselves the level of compliance with the law. And this is very important because in Europe we have over 26 million SMEs, including over 24 million micro enterprises, and they don't have the resources to hire law firms. So it's important to provide them the adequate instrument for them to assess the level of compliance. Finally, and I will stop here, we have just recently published a white paper on GDPR certification with the European Center for Certification on Privacy. You are free to just scan the QR code and to access this version. Thank you very much. I'm sorry I've been 1 minute too long.
Thank you, Sebastian. And now I would like to invite the audience to ask questions and make comments. And I ask Charles Rabb to give the floor to members of the audience because I can't see the audience from here. So Charles, please take over the floor.
We have probably about 15 or so minutes for questions, and I just wonder whether there's anyone in the audience who, I see a couple of hands up already, but I want to ask whether there's anyone in the audience who represents or is part of a consumer organization or an NGO in that field who may want to ask a question. But before they raise their hands, gentleman in the front row, and there's one further back as well.
Hello, I'm Bernd Vliet from law firm Timelex. Thank you for the interesting panel. It's quite surprising that none of the panelists mentioned the word AI today. It's didn't happen to me at the conference yet. But I wanted to ask a question to Merit, but actually Colin already touched up on it. The many DPAs have a lack of resources in the EU, and I was wondering indeed whether it could be an idea to, if an DPA discovers a violation that is not so bad that the processing activity needs to be stopped immediately, it could be an idea that they impose or order to get certification within 2 years from the order. But Colin said that there are certain legal issues there. And I'm interested to hear what are those legal issues, because the GDPR gives the power to a DPA to order a controller or processor to bring the processing activity in compliance with GDPR in a specified manner and within a specified time frame. So yeah, I'm wondering what those legal issues are.
Yeah, go ahead.
Yeah, I can start, and probably Colin can extend my answer then. Right now already, so we don't have this thing, no fine possible, but it plays a role, certification plays a role, also in setting a fine or thinking about ordering something. And perhaps only to be sure, even so the European Court of Justice ruled that there is no compensation to be paid in compensation cases when everything was according to the GDPR, state-of-the-art technology, and so on. So if you, in the moment of when the data breach was happening, everybody was sure they did what they could according to the state of the art, not better, not necessarily better, but still something happened, still there's harm, and there was no compensation. This is a little bit, if the certification works, it's the same. So we have a level where it's a guaranteed situation, and I think the one question is, has something changed then? Are the changes also covered? But still, state-of-the-art technology, everything was checked by a third party. And here now, of course, now the question, who is the third party? In the European schema, usually it's a commercial body. It's a company doing that as a certification body, and they want to earn money. It could be that also the DPAs do it themselves, and we thought about that in Schleswig-Holstein because we did it before the GDPR. So right now we only address the public service in Schleswig-Holstein for that, but even then we tell them it's very ambitious to do that, and probably it's better to have a standardized thing where the certification is done in a regular in a regular way, so it's repeating and everybody is firm in that. So if we order now, bring your data processing in line with the GDPR requirements, of course we can do that. If we say, but you have to use this, and we know already there are so few companies and they are the only ones, so we force them to invest, and perhaps even we would force them to do something in Germany. So we said, then right now you've seen we have several in Germany. So this may be something where we can say, yes, do that. We are encouraging you at least. Perhaps you have other ideas. We can have a negotiation on that. So this will work. But if we say in a country where there's only one accredited certification company as a body, and say you have to do that, that's probably not possible because we are interfering with the market, because there might be further candidates. If it's really something where only one is interested, this may not play a role. And of course, all the European data protection seals, they are interested. Right. So this may be something where we can negotiate, but not order.
Okay. Go ahead, please.
Yeah, no, I think it's clear that there shouldn't be any arm twisted. But I think at the same time, the idea is very interesting because now we already have 3 European seals, so there is no monopoly on it. There is possibility to choose. And the way, for instance, for Europe, I say the way we addressed, we decided that from the research side, we were qualified to develop a norm, but we don't have the expertise. I mean, we could acquire, but it would not be efficient to start delivering certification ourselves. So the seal, the scheme is made available to the largest certification bodies. So BSI, DNV, SGS, Bureau Veritas, and so on. So people with the same scheme, you have a competition because they are competing against each other. The same for implementers. You can also do it yourself. You can prepare the certification yourself and just request a certification body. So I agree, we have to be careful not to force someone in a position to say, oh, no, you have to pay a lot to be. But I think now we have the conditions to have competition in the market. Having the European seal means that you have certification body from different countries who can deliver certification. A very good example for Allianz. The certification body was not based in Germany. It's a certification body in other European countries who can, because they ask different offers and say, oh, this is the best offer, and based on the GDPR, accredited certification body can deliver seals all over Europe. So there are good elements. Then there is also the possibility to say, it's not an obligation, but that can simplify, because for the DPA, it's also a way to reduce a little bit the pressure to go and verify. Again, 26 million SMEs in Europe. And as I heard recently, even if he was not speaking on behalf of the authorities, but one of the commissioners last week in Venice of one of the European authorities said, if we had to request all companies in my country to stop processing data until they are compliant, we will block the country. So even authorities are aware of that. So certification is a way to distribute the workload, to distribute the burden, not to replace, not to substitute to the authority, but it's a very powerful instrument, a multiplier, multiplying effect instrument for that. Then the other aspect is not only the sanction, but I think one thing where the authorities could play a massive role to facilitate the adoption, again, in line with Article 42, shall encourage, is, for instance, when DPAs, when they have called for tenders, third-party service providers, right, to say, to include certification, not necessarily as a mandatory, but at least as a criterion, to say, if you want to apply for this service, certification will be an element that we would take into account, regardless of the scheme. It's not to support a scheme in particular, but this could be a very efficient way. Another way could be for DPAs to encourage the national authorities administration to walk the talk. Again, we see through the GDPR that certification better protects the rights of the data subject, is more reliable. So why not walking the talk? Why not asking the national authorities, when you do call for tenders, at least don't make it mandatory, but you should mention certification as a positive element to select among different service providers to ensure that we ensure the highest level of protection for data subjects. So I think that can be done. Finally, maybe I will end that, and I know for EDPB it's a lot of work, so I'm really not, I know it's not easy to bring together 30 national authorities, so 27 of the EU, the 3 of the EEA, to agree on common interpretation, common vision. And they have a lot of work to be done there. But maybe one thing, food for thought, and one thing that could be interesting is perhaps at a moment to hear from EDPB a better communication on what is the value of certification? Why is it particularly useful? Why, as a SME, should I choose a certification which is costly rather than just signing a SCC? And there is, in the GDPR, there are answers to that. As you mentioned, Marit, there are many elements. And perhaps having EDPB, EDPS, and the national authorities being more communicative on that would be very, very useful.
Just very quickly. Yeah, I mean, a lot more needs to be done in this area. I think this notion of using certification as a compliance instrument is perhaps easier in countries like Canada, where the commissioner does not have order-making powers and does not have fining powers, because when an investigation is concluded, they often develop what are called compliance agreements. Okay, we don't want to go to court on this, it's going to be expensive. Let's have a compliance agreement, and a certification can be part of that agreement. But so far it hasn't been used a great deal, and where it has been used, it's in relation to security standards, the ISO 27000 series. But there's no reason why it couldn't also be used for a broader GDPR privacy law certification, like privacy, Euro privacy.
Thank you.
Thank you. I'm Jean Rossi from University of Paris 8. Thank you for this very interesting panel on a topic that we haven't talked much about in these last few years. I have a question which will express some clear skepticism towards certification. I don't want it to be interpreted as skepticism towards the seriousness of the work of certification authorities, but skepticism towards the value of certification for compliance and from the perspective of compliance with the law. And I would be interested to hear your thoughts on that. I think it was in 2018, around 2018, there is a research group in the Institut Mines Télécom in France who published a study on certification because they were expecting a lot of certification schemes. And one of their conclusions, they included economists in their group, was that certification in many cases could be used mainly by bad actors or people who are not that compliant, because it gives them, it can give them an appearance of compliance at the moment when they got the privacy seal, and maybe they can, in some cases, select the certifying authority that they like, and maybe some of them have a reputation that this may be a bit more interesting to them than others that are more serious. It can also lead to some extent to some privatization of bureaucracy and create costs that are kind of like taxation, but it's not taxation, but it's private taxation. Especially if it doesn't add anything else than what data controllers already have to comply to in the law. So I can understand the added value for data controllers and especially processes, especially when they have to answer to tenders and so on. I'm not saying that there is no value in certification, especially from the point of view of data controllers and especially processes. I'm not saying that certification authorities are all not serious and not to be trusted, not at all. However, I still wonder, especially in the face of maybe a risk for some privatized bureaucracy, to know what the added value is in the European Union, in the EEA, of certification with regards to the goal of compliance. Thank you.
Maybe I can give some answer. I think it's a very good question, a legitimate question. Is it really worse? Is it really, is there any side effect or counterproductive aspect? I think one of the reasons, by the way, little parenthesis, Something very interesting that in French, the GDPR translates the seal or the certification into label. In French, it's label, and label usually is perceived as something quite weak in the field, in the world of certification. Why it's clearly a certification, it's more than a standard certification, it's a certification with legal effect. So that's very distinct animal. It's not a label, it's a certification. And when you see about this risk, Recital 100 and Article 42 both state that the purpose of the certification is to build trust in the compliance, to enable third parties, in particular data subject to access. So what we did from the research is to work a lot on how to ensure a highly compliant and reliable assessment process while making it efficient, because we need to take into account this 24 million SME or micro enterprise in Europe. So that's it. There is no, for a bad actor, no real interest, because that will not protect them from a fine. On the other hand, when we see the first European seal, which have been delivered, we have seen companies like Allianz. I don't think that Allianz is a bad actor, and they did it because they wanted to be proactive. We've seen startups on AI domain. We've seen companies like PricewaterhouseCoopers. We have currently, there is in the process a hospital. So you have different stakeholders. Recently, last week, there was a French company which is working with the French ministries and the research community to make available personal data to researchers. Le Centre pour l'accès sécurisé aux données. I think it's a non-for-profit institution working directly with the minister. So what we see from those who are coming usually are are not bad actors. We have seen, that being said, sometimes companies, in particular from China, trying to find a way to get a seal. Right. And then the good point is that the criteria are very strict, and we have also clear criteria regarding the risk for transfer to third countries. So usually they try their interest on the block, or if they try to push, we try also to protect. But there is a risk. But I think in order to be certified, you need to comply with all the requirements, and the requirements are very strict. It's not a window dressing exercise, it's really assessing each and every one of the obligations. And in case a certification body will deliver would be complacent with the delivery of a certification, the certification body can be fined to the same level of a data controller. So you have quite a number of mechanisms. I wouldn't say there is zero risk, but I would say to have a complacent certification would be highly, highly risky for a certification body and could be highly costly. Then what
I need
could
to
happen,
intervene
just
at
to
that
conclude,
point.
is sometimes companies which have been sanctioned, they have a problem of reputation, and then certification may be attractive to try to reestablish their reputation, but not to do window dressing exercise, to say, no, look, we are compliant, because the market thinks they are not trustable. That can happen, I would say.
Yeah, but I mean,
We are approaching the end of our time limit. I'm sorry to say that. So I would like to ask Charles to summarize the discussion, because he is the last speaker.
Well, very quickly.
just a quick,
Very quickly, yes.
just a quick point on that. It's not so much bad actors, it's that certification bodies cannot make legal judgments about the tricky issues in the GDPR. And that's the issue. You know, is that a legitimate interest for collection? And so, you know, you're reliant on there being a stable understanding about what the law is and what the company's doing under the law, I think. And that is not always in place, right?
And in processing operations, if you want to certify everything, you have to go down dig down into everything. Like the operation system, of course, there's a stop, so you won't do that. So there might be some privacy whitewashing if you have a dedicated scope, which is it's okay, or maybe even something where you can set something where it's you agree on. But of course, it's not extensible to everything. And we will see whether the Microsofts and Facebooks and Googles will have a certification next year for some very dedicated small
Charles,
stuff.
please share your concluding remarks.
Yes. Yeah, I apologize to a member of the audience who has a question. Perhaps you can ask it privately afterwards. I've been asked to sum up before we have to finish. very famous German sociologist and philosopher Niklas Luhmann wrote quite a lot about trust. There's an enormous academic and other literature about trust. And here we're talking about trust, but we're talking really about trustworthiness and the demonstration of trustworthiness, the engineering of trustworthiness. Now, what Luhmann said was that trust is important socially because it simplifies things, relationships. You trust other people rather than trying to research them and find out all about them in order to know about them. So it simplifies. So here we have a complexification of trustworthiness mechanisms in order to simplify the trust that people may have in the companies that are certified trustworthy. So trustworthiness, I think, is the term that may be even more important than trust. Because trust, we use the word too casually, but I think trustworthiness and its demonstration, its public demonstration and its certification, I think is what we've been talking about this morning. I wanted to thank the panelists for very, very trenchant and insightful contributions, which I learned a hell of a lot, and I hope the audience did as well. This subject will not go away. I don't know whether we will treat it again in a panel, but somebody ought to bring it together as a focus of attention in further regulation and also in further development of the implementation of human rights. So thank you all very much, and thank you for the audience for getting here early and for listening so eagerly. Thank you all.
And special thanks to the
for
technical
Ivan.
staff.
Thank you,
Yes.
Ivan, for setting
Special
this
thanks
up.
to the technical staff who have solved the complex technical challenges of remote moderation. So I think let's applaud them. They deserve. And now coffee break.